So today I'm going to go over the NCCT examination study guide. I gave this to you, I believe, the week that I went out on maternity leave, and you were supposed to put this information on note cards or go through your note cards that you already have to make sure that you know this information for the certification exam. Now, this handout is on Classroom, so if you need a copy, you can go to the student printer and print it if you like a hard copy, or you could follow along with your computer or Chromebook, whichever you choose. So I'm going to add some things to this study guide. Probably not a whole lot, but it's enough information that will probably make your head hurt. And I'm pretty sure you'll wish that I forgot to do this video. So the first thing or first parts that we're going to go over are several statutes and laws that have been known to come up on your test. This information is not in caduceus. Again, this information is not in caduceus. So the first one that we're going to go over is the Truth in Lending Act, also known as TILA. And the handout on this can be found on Classroom as well. It's under Medical Billing and Coding Laws. I'm going to give you the highlight points for this act. The Truth in Lending Act, TILA, protects you against inaccurate and unfair credit billing and credit card practices. It requires lenders to provide you with loan cost information so that you can comparison shop for certain types of loans. Do not ask me why this is important for you to know on a billing and coding test, because this has absolutely nothing to do with billing and coding. But it's good for you to know in case you are interested in getting a loan later down the line. Again, the Truth in Lending Act protects you against inaccurate and unfair credit billing and credit card practices. The second one is the High Tech Act. And go back to that same document. Well, it'd be nice if it let me go to the next page. Next page. Okay, the High Tech Act, it stands for the Health Information Technology for Economic and Clinical Health Act, enacted as part of the American Recovery and Reinvestment Act of 2009. This was signed into law on February 17, 2009 to promote the adoption and meaningful use of health information technology. Basically, what all of that big word stuff means is that your healthcare information will not be used when it's not supposed to be. It addresses the privacy and security concerns associated with the electronic transmission of health information, in part through several provisions that strengthen the civil and criminal enforcement of HIPAA rules. HIPAA, as you know, is confidentiality. The High Tech Act is the transmission. It protects your information, your healthcare information, when transmitted electronically. And also know that HITECH was signed into law February 18, 2009, but it was effective February 18, 2009. Now the information here is a little bit more detail of what HITECH entails. Excuse me, but you won't be asked that information. The main information that the test is asking for is right here in this paragraph. And the next thing that I'm going to add is the birthday rule. Y'all don't need to see me. Billing and coding. Alright, so what you need to do is go to billing and coding, the document billing and coding 1, and the birthday rule is in regards to dependents, meaning children. Who covers the child? There are 2 instances or 3 examples that I will go over with you. This is a really big thing on the test. You need to know it, need to understand it, because they will ask you. So if you skip down to where the bullet is here that says child of divorced parents, the child of divorced parents, the custodial parent, meaning the parent who has custody, their insurance plan is primary on that child or children. If the parents are remarried, the custodial parent's plan is primary, the custodial step parent's plan is secondary, and the non-custodial parent, meaning the parent that does not have custody, is tertiary or third. An exception is made if a court order specifies that a particular parent must cover the child's medical expenses. If you have children or a child living with both parents, if each parent subscribes to a different health insurance plan, the primary and secondary policies are determined by applying the birthday rule. The physician office staff must obtain the birth date of each policyholder because the birthday rule states that the policyholders whose birth month and birthday occurs earlier in the calendar year holds the primary policy for dependent children. The year of birth is not considered when applying the birthday rule determination. If the policyholders have identical birthdays, the policy in effect, the longest, is considered primary. Example 1. A child is listed as a dependent on both his father's and mother's group policy. Which policy is primary? The mother's birth date is 3/6/59 and works for IBM. The father's birth date is 3/20/57 and works for General Motors. The answer is the mother's policy is primary because her birthday is earlier in the calendar year. Again, do not get confused or bogged down with the date, the year of the person's date of birth. Because her birthday comes before her husband, she is listed as the primary for their child. Example 2. A child is listed as a dependent on his father's group insurance policy and his mother's group health insurance policy. The father was born January 1st, 1956, and the mother was born on March 4th, 1945. Which policy is considered primary? And as you can see, the answer, the father's policy is primary because his birthday is earlier within the calendar year. Now this one, let's see. Okay. A dependent child is covered by both parents' group policies. The parents were born on the same day. Which policy is primary? The father's policy took place on March 6, 1986, and the mother's policy took effect on September 6, 1992. Now, based on the information that was given to you in the second paragraph, who should cover this child? The father's policy is primary because it has been in effect 6 years longer, which is what is said here in the bottom. If the policyholder have identical birthdays, the policy in effect, the longest, is considered primary. If you need to take some time to write that down, well, you need to write that down. If you need to take some time to denote it, make a star, put a box around it, whatever it is that's important to you, do so, because this will be on the certification exam. Okay, so let's go to Federal False Claims Act. It's a federal statute for false billing. If someone is fraudulently billing claims, which I've talked to you ad nauseum about because of the court case that I was subpoenaed to testify at, they violated the federal false claims. That was violated. They submitted false claims. Things didn't happen in the office, and they ended up going to court and probably going to jail for a really long time. So if you know that someone is doing something illegal, do not put yourself in a situation as to where you could lose your license, your livelihood, and your freedom. Key Town allows a private citizen to file a lawsuit against the federal government. So if you feel or find out information that is again illegal and it is a federal offense, you can file or sue the government. Excuse me. If you plan on doing this or you know someone trying, they need to make sure they have all their information. I's dotted, T's crossed, that type of thing. Because if you're going to sue the federal government, please make sure that you have some accurate documentation. The Stark Law. The Stark Law is a conflict of interest statute. It is a limitation on certain physician referrals. And what that means is different facilities, medical doctors refer to outside facilities. For example, for me, we use One Step Imaging. We use Red Oak Imaging. We don't specifically just use one imaging facility. What happens is if you are referring out to different facilities, you have to limit which one. You have to limit. You have to be fair. I'm trying to explain this the best way I can without confusing you. You have to use multiple facilities. You can't just use one because that seems like favoritism. And when you have that happen, you have kickbacks, which is the come down some right here. A kickback is a form of negotiated bribery in which commission is paid to the bribe taker. So at the company that I used to work for, we used a facility in San Antonio, which we shouldn't have done, or which shouldn't have even been negotiated, to do surgeries and injections. Well, that was the only facility that was used in order to you to do to do surgeries and injections. We are in the medical center, in the hub of it. So why can't we use the different surgery centers or hospitals that are in Houston? The reason being is because the owner was getting a kickback from the hospital for every patient that he sent. In lieu of that, he was breaking a law or a statute, anti-kickback statute, a criminal statute that prohibits the exchange of anything of value. In this case, it was money. Now, how much money they were making on each patient, I don't know, but we were pressured to send these patients out to San Antonio. We had patients that could barely walk. We had patients that could barely sit in a car for 30 minutes just to get to therapy. And so a lot of our patients pushed back and said, I'm in Houston and there's no reason why I should have to go to San Antonio in order to get this procedure done. And they were correct. So with the Stark Law, you don't want to be caught up in just going to one facility because that's a conflict of interest. That's the only facility you can find. I can understand if it's a small town and there is only one facility, but we in Houston, major metropolitan areas, there's no reason why you should have to just focus on one facility. That can cause an issue. And then you also get caught up in maybe being accused of having kickbacks or taking bribes or illegal monies. And that's not what you want to be about either. I hope I didn't confuse you because those things are confusing. And I hate to be like this, but if until you experience it, you get it. But I don't want you to ever have to go through what I did. Cobra. Cobra, you have a note card on this. Is the Consolidated Omnibus Budget Reconciliation Act, and it allows families to continue health group plans benefits for a limited time. For a limited time means after quitting a job or a place of employment. So you have the option of signing up for your health insurance, but you do pay a higher premium than what you did with your check. You are no longer with the company that you're working for, so those group premiums that your company paid, essentially you're paying for them in order to keep your insurance. Cobra can last anywhere from 3 months to a year, but this is an out-of-pocket expense that you do have to pay for if you want your insurance to continue. A statute of limitation. Statute of limitations is the maximum time after an event within which legal proceedings may be initiated. For example, your PIP. And I'm not telling you what it means because we should know. But for your PIP, if you are in an accident and you want to use your PIP, you have 3 years to file a claim. That is the maximum time after an event that you could file for your injuries. For a motor vehicle accident, if you're in a car accident and you feel that you need to sue the individual who caused bodily damage, vehicular damage, the statute of limitation is 2 years. You have 2 years to file a lawsuit against that individual who did wrong. Insurance companies or your insurance policies, they have a statute of limitation. Depending on which insurance carrier you have or that you're billing to, there's a statute of limitation that you can file your billing to. Medicare is 45 days. Blue Cross Blue Shields, Aetna, Major Medical are 30 days. There are some insurance policies that are 90, but they're few far in between. But again, that is a statute of limitation, the maximum amount of time. So I finished up statute of limitations. The next concept is the Fair Debt Collections Practice Act. It eliminates abusive debt collection practices by debt collectors. The reason why this is important is because when you go to a doctor's office and you don't pay a bill, they can send you to collections. And with that being said, it's the same thing for any type of bill that you may owe. Credit card bill, utility bill, if it's not paid within a timely fashion, then that company has the right to send you to a collection agency to collect their loss. With this act, these are the rules that the companies have to follow. So communication has to take place at a convenient time with the consumer. It has to be after 8 a.m. and before 9 a.m. I'm sorry, this should be saying 9 p.m. I'll change that. That doesn't make any sense. There you go. All right. Communication has to take place after 8 a.m. and before 9 p.m. A representative can talk to the claimant's attorney if it gets to that point. A consumer's place of employment unless prohibited by consumer employers. So a collection agency can call you at work unless it's prohibited by your job. Communication with a third party unless given permission by consumer directly, meaning that they can talk to another company that may be handling your claim unless you say they can't. Ceasing communication. You cannot contact the consumer if a debt collector is contacting in writing, meaning that if you are being harassed, they call you all the time, you can send a letter in writing stating, please do not call me, and they cannot call you anymore. That does not mean that you don't owe the money. And you cannot be harassed or abused. It may seem that way, but they're just doing their job. False or misleading representation. The debt collector may not use any false or deceptive acts to speak with the consumer. So they cannot say that they're from your child's daycare center and they say, well, no, not really. I'm trying to collect some money from you. Or they can't say that you won a sweepstakes and lie and turn around and say, well, no, the sweepstakes is you owe me money. Nothing like that. They have to be upfront and honest, say why they're calling, what they want. No false or deceptive acts. They cannot use unfair practices to collect fees. The validation of debt. You must have something in writing to state what you owe. No one can just call you and say you owe $300 and there's no proof. You can have multiple debts, so you can have multiple debt collectors call you. Legal actions can be taken by debt collectors, meaning they can sue you for their money eventually. Wages can be garnished generally due to a court order, and that's when it's really, really bad. You must owe a lot of money. And I hope none of you ever have to go through this or put yourselves in this type of situation. But again, the reason why this is important is because if you owe a medical bill, your fees that have not been paid will be sent to collections. And the rules that I just went over is what you can expect for someone to call you or put you through. So I keep doing that. It's cold. Topics to remember: AOB is assignment of benefits versus accept assignment. The assignment of benefits is a document that the patient signs giving permission for the insurance company to pay directly to the provider. Accept assignment is where the doctor accepts the fee in which the insurance will pay. Do not forget on your CMS 1500, your DN, DK, and DQ. That would be in the record for you to denote who saw the patient, if it was a referring provider or ordering provider or a supervising provider. Now with the supervising provider, do not forget that this is generally used for individuals who are not physicians, such as a nurse practitioner. You may be asked which version of the CMS 1500 is currently utilized, and it is 02/12. If you have a copy of a CMS 1500 in your notes or in your folder, look at the bottom corner and it will indicate to you 02/12. That is the current version. Anything else is incorrect. ICD indicator, which is also known as ICD IND, 0 equals 10, and this is the only code or the only ICD codes that you should be using. ICD 9 is no longer being used. DX, diagnosis pointer. You need to understand how the diagnosis pointer correlates to the diagnosis codes. So you may want to pull out one of your CMS 1500s and review that. These you should already have on note cards, so I'm not going to go over them. This is a question that may occur. Errors that delay processing, keyboarding errors or incorrectly entered information, the data service, procedure codes, diagnosis codes, and the policy identification number. Those numbers sometimes are transposed in typing the information into the computer, so it may come across incorrectly, but that is a question. Let's see. Okay. Balance billing, the collection of fees. The collection of fees after insurance has paid its portion. So I'm going to use this example that's on your notes for numbers purposes. Let's see if I can find it. Okay, right here. So if the physician's fee for a given service is $60, the insurance company paid $52. The adjusted amount would be $8. Now, again, I'm just using this for an example, so don't pay attention to the words and what it's saying because this is talking about something totally different. the difference would be $8. So with balance billing, you would have to give the balance, which would be $8. If the doctor charged 60, the insurance company paid 52, the patient owes $8. That's what balance billing is. And it tells you this right here. As claims are sent to the insurance companies and payments are received and posted, the patient billing system uses this information to generate statements. It is customary for patients to receive a bill or a statement each month from the practice if there's a balance due. So balance due, balance billing, same thing. Balance billing is not allowed with non-par, meaning non-participating physicians in an insurance plan. EMOB is the explanation of Medicare benefits. This replaced the MSN, the Medicare Summary Notice. Know the difference between Medicaid and Medicare? There are questions on them, and you should already have a no card or no cards for both Medicaid versus Medicare. Excuse me. MDM is medical decision making, and that is commonly found in your E&M codes, medical decision making. NOS, not otherwise specified, is a condition that is not completely described in the medical record. And NEC, not elsewhere classified, no code matches the exact situation. We've talked about how to code as far as which one comes first. The first listed code reported should be the major reason a patient reports to the doctor's office unless the code is preceded by a blue dot. And we talked about the blue dot. If you need to refer to your ICD-10 book and look at the blue dot, I would recommend that you do so. Alright. I believe that I've covered everything for this review. It's probably going to take you a couple of minutes to go through this because there was some extra at the beginning. I apologize for being a little delayed. It's 1:02 in the morning, so I apologize. If I have to come back and re-explain the Stark law, anti-kickback statute, and kickback, I understand because that is confusing. Your portfolios are due April 28th, and I have posted that on Classroom right here. Portfolios are due April 28th. Yes, I will be back by then to collect them, grade them, so don't forget about them. I think that's all for now. I will also post review questions from your last chapter and good night.